cases, you were reversed less than 3% of the time. And in some of the instances, you were reversed only to have your decision later upheld. I noticed one case, Territory of Guam v. United States, in which you were initially reversed, but then a unanimous Supreme Court reversed that decision, and siding with you, in an opinion written by Justice Thomas, and aligned with your view. You want to quickly talk about that case?
Well, that case is kind of legally complicated. It was a CERCLA case, which is a Superfund cleanup kind of case, where the country of Guam, which has a dump site on it that was used by both the citizens of Guam and the United States before the 1950s, when the United States was stationed there. Military operations happened out of Guam, and there was a lot of dumping into this site. And over time, the site got contaminated, and Guam was charged with having to clean it up, which is millions and millions of dollars. And there are statutes, very complicated statutes, about the circumstances under which you can seek contribution, under which a country like that can ask for the United States to pay some of that cost, or other countries to pay some of that cost. And that was sort of the nature of the dispute. And I did a statutory interpretation about whether or not Guam's action could proceed. The United States filed a motion to dismiss, saying that all of the technical requirements of the law weren't met, and that the action had to be dismissed. And I denied the motion to dismiss after interpreting the statute, saying that the action could continue. The D.C. Circuit reversed my view, had a different reading of the statute, saying that the motion to dismiss should have been granted, and dismissed the case. And then it was appealed to the Supreme Court, and as you say, the Supreme Court reinstated the action, saying it could proceed.
Very good. Thank you. In 1972, in Brandsburg v. Hayes, a 5-4 court did not recognize the reporter's privilege in the context of criminal grand jury testimony. I spoke with you earlier at length about Times v. Sullivan and First Amendment issues, so this will be my last question on this. Since the court's decision, my state, like many other states, enacted strong reporters' privilege laws to protect journalists from having to divulge unpublished materials, confidential sources. How would you approach balancing the need to protect journalists and the role they play in informing the public against the need for law enforcement officers to gather information?
I would apply the precedents of the Supreme Court in this area. It would depend on the circumstances. As I mentioned, press freedoms is one of the fundamental First Amendment rights. The court has a number of precedents in terms of expressive freedom, press freedom, and in every case, there'll be a specific set of circumstances regarding an alleged violation of the right, and the court would need to look at the facts and circumstances, the prior precedent, in order to determine whether that particular regulation could be upheld.
Okay, thank you. This is my very last question, Chair, before all of us get to eat lunch, including you. And that is really the important role of dissenting opinions. Justice Ginsburg once said this. She said, "Dissents speak to a future age. It's not simply to say my colleagues are wrong and I would do it this way, but the greatest dissents do become court opinions, and gradually over time their views sometimes become the dominant view." When Justice Ginsburg's rabbi gave a eulogy at her memorial service here in the Capitol, and some of us were fortunate enough to be there. He said, "Justice Ginsburg's dissents were not cries of defeat. They were blueprints for the future." What do you think is the purpose of a dissent? And you want to talk just a little bit about that, this idea that they can be blueprints for the future?
Thank you, Senator. on the Supreme Court, there are 9 justices, and in every case, they're all sitting together to hear the issues in a case. And one hopes, and it often happens, that the justices agree as to issues in cases. That I believe that the vast majority of cases that the justices hear are actually not. There is no dissent, that they agree to the outcome. But there are cases in which, after deliberation and collaboration and consideration, the justices may disagree about how the case should be resolved, and there's a mechanism for every justice to decide whether they're going to join others, either in the majority, whether they're going to write a separate opinion that might agree with the majority but wants to make a different point, or whether they want to dissent. And sometimes more than one justice might dissent or join a dissent. It's a way of expressing one's own view that may differ from your colleagues. And with respect to the point that you made, there are actually many justices in history who have used the dissent mechanism to discuss the law in ways that others find over time to be more persuasive. And so I'm thinking of the first Justice Harlan, who dissented famously in Plessy versus Ferguson. He dissented alone. All of the other justices agreed with the proposition of separate but equal, and he said no in a dissent. And his dissent, generations later, became, according to Justice Thurgood Marshall, became the blueprint for Justice Marshall to make arguments that led to Brown versus the board. So there is the opportunity for justices to describe their views in ways that become persuasive to others in the future.
Thank you for all you've given us the last few days. We look forward to working with you. Thank you.
Thank you.
Thanks, Senator Klobuchar. And we're going to break now for a 30-minute lunch. I'd say to everyone that when we return, if we stick to 20-minute rounds and don't yield back time, we'll be finishing in something around 4.5 hours, which would take us to about 7 o'clock. So that doesn't include a break, but we'll consider that later on. Thank you, Judge, again.
Thank you.
Thank you. Sorry, can you ask one more follow-up question? Do you expect any Republicans on this committee to vote for it? So you don't know if we're gonna have a community split. I'll see you later.
Yeah, so here. I am. When you prepare yourself. No, I was just saying that there's he's got a lot of
Oh, so they're, do they want shots or anything?
back at 2:20.
So, do they want shots now?
So like I said, they're coming in and out of stuff to shoot. They're coming in and out of this. So, but right now, I don't think it's
Okay, when do you think it'll land? Oh, really? Okay. Better than 10.
All right, we're good there.
So would you like to comment at the outset of those who are looking for a label? What your position is on judicial philosophy?
I am acutely aware that as a judge in our system, I have limited power, and I am trying in every case to stay in my lane. I ensure that I am proceeding from a position of neutrality. And then there's the factual record. I am evaluating all of the facts from various perspectives, trying to understand what those who created this policy or this law intended.
If a senator were to ask you today about proposals about changing the current size of the Supreme Court, what would your response be?
In my view, judges should not be speaking to political issues, and certainly not a nominee. September 11th was a tragic attack on this country. We all lived through it. We saw what happened. Federal public defenders don't get to pick their clients. They have to represent whoever comes in, and it's a service. That's what you do as a federal public defender. You are standing up for the constitutional value of representation. I think that experience in the criminal justice system, whether, as you say, on the prosecution side or the defense side, having actual experience is an asset as a judge.
Do you agree with Justice Kavanaugh that Roe v. Wade is settled as a precedent? And will you, like Justice Barrett, commit to obey all the rules of stare decisis in cases related to the issue of abortion?
Roe and Casey are the settled law of the Supreme Court.
Critical race theory, as you know, originated at your and my alma mater at the Harvard Law School. In your understanding, what does critical race theory mean? What is it?
Senator, my understanding is that critical race theory is it is an academic theory that is about the ways in which race interacts with various institutions. It doesn't come up in my work as a judge. It's never something that I've studied or relied on, and it wouldn't be something that I would rely on if I was on the Supreme Court.
But Judge, with all due respect, and I'm telling you what, I'll be direct with you. I am questioning your discretion and your judgment. That's exactly what I'm doing. It really bothers me when in every case, child porn case you've had discretion, you've sentenced below the guidelines and below the government's recommendation.
If you were to look at the greater body of not only my more than 100 sentences, but also the sentences of other judges in my district and nationwide, you would see a very similar exercise of attempting to do what it is that judges do. Congress is the body that tells sentencing judges what they're supposed to look at. And in every case, I did my duty to hold the defendants accountable in light of the evidence and the information that was presented to me.
Back in 2016, you presided over a case brought by the RNC against USAID related to then presidential candidate Clinton, and you ruled in favor of the RNC. In this case, you reinforced your deserved reputation for following the law, not a partisan agenda, because you ordered USAID to produce thousands of pages of documents related to Secretary Clinton.
We've been watching history unfold.
have only been 115 justices in our nation's history. Judge Jackson's nomination, of course, is historic in more ways than one. Her nomination, pending a confirmation by the Senate, will bring us one step closer to having a Supreme Court that is more reflective of our nation, the American people, our constituents, and their faith in the courts. That's central to our democracy. They lose their faith, then democracy loses. Judge Jackson is no judicial activist. She is not a puppet of the so-called radical left. She's been praised by Republican-appointed judges for her jurisprudence. Lawyers from the right and the left who have appeared before her in court have called her judicious and even-handed. Judge Jackson is not anti-law enforcement. She hails from a law enforcement family. And no, she's not soft on crime. Her background as a federal public defender would bring an informed perspective of our criminal justice system to the Supreme Court. I would say that Judge Jackson's background is not a liability to the court. It's a much needed asset to the court.
I'm a bit troubled by some of the positions you've taken and arguments that you've made. I'm eager to understand why in some instances you found that you could not decide a particular issue, while in other instances you enjoined a Republican administration from implementing its policies. I'm also interested, as others have mentioned, in your opinion, why pro-abortion, dark money groups like Demand Justice, and anti-religious liberty groups are pouring millions of dollars into a public campaign in support of your nomination. Judge Jackson, these are some of the questions and concerns I have. I assure you that you will have every opportunity to address these concerns as the committee evaluates your ability to fairly and impartially deliver justice should you be confirmed.
This is not a normal day for America. We have never had this moment before. And I just want to talk about the joy. I know tomorrow in the coming hearings we're going to have tough, hard questions, but please let me just acknowledge the fact that this is not normal. It's never happened before. The Senate is poised right now to break another barrier. We are on the precipice of shattering another ceiling, another glass ceiling. It's a sign that we as a country are continuing to rise to our collective cherished highest ideals. We have had 115 Supreme Court justices, and we shouldn't diminish the accomplishments of mostly these 108 white men. They were extraordinary patriots who helped shape this country. But now we are seeing, to the highest court in our land, a hopeful day like this.
It has to be an actual dispute, that federal courts cannot simply issue advisory opinions on a question they may have a view on. And one component of Article 3 jurisdiction is the requirement of standing, that in order for a plaintiff to have standing to bring a case, that plaintiff, at least generally speaking, must have a real and concrete injury. Is that right?
That is correct.
So, for example, that means that even if I might have a disagreement with some particular policy or some particular law, that I can't bring a case unless I am personally aggrieved by that policy or that law. So, for example, you're in my alma mater, Harvard, is currently being sued for its explicit and, in my view, egregious policy of discriminating against Asian Americans. Even though I think that policy is egregious, I, as an individual plaintiff, could not bring a lawsuit challenging it because I am not Asian American. Is that right?
If you brought a lawsuit, the court would have to evaluate whether you had an actual injury in order to be able to determine whether it had subject matter jurisdiction to hear the suit.
But if I'm not in the class being discriminated against, then I don't have the ability to bring the lawsuit. Is that right?
I think you'd have to have an actual injury. Certainly people, I think, who are in the class could claim that they had an injury for that purpose.
So now you're on the board of overseers of Harvard. If you're confirmed, do you intend to recuse from this lawsuit?
That is my plan, Senator.
Okay. We discussed yesterday how the standard for race discrimination was strict scrutiny. The court has laid out a different standard for gender discrimination. What is the constitutional standard that applies to gender discrimination?
Gender discrimination, the court has held intermediate scrutiny applies, which is that the government has to have an important interest, and the tailoring doesn't have to be as narrow.
Right. So yesterday, under questioning from Senator Blackburn, you told her that you couldn't define what a woman is, that you were not a biologist, which I think you're the only Supreme Court nominee in history who's been unable to answer the question, what is a woman? Let me ask you, as a judge, how would you determine if a plaintiff had Article III standing to challenge a gender-based rule, regulation, policy, without being able to determine what a woman was?
So, Senator, I know that I'm a woman. I know that Senator Blackburn is a woman, and the woman who I admire most in the world is in the room today, my mother. It sounded as though the question was...
But let me ask, under the modern leftist sensibilities, if I decide right now that I'm a woman, then apparently I'm a woman. Does that mean that I would have Article III standing to challenge a gender-based restriction?
Senator, to the extent that you are asking me about who has the ability to bring lawsuits based on gender, those kinds of issues are working their way through the courts, and I'm not able to comment on them.
Okay, if I can change my gender, if I can be a woman, and then an hour later, if I decide I'm not a woman anymore, I guess I would lose Article III standing. Tell me, does that same principle apply to other protected characteristics? For example, I'm an Hispanic man. Could I decide I was an Asian man? Would I have the ability to be an Asian man and challenge Harvard's discrimination because I made that decision?
Senator, I'm not able to answer your question. You're asking me about hypotheticals, and
I'm asking you how you would assess standing if I came in and said I have decided I identify as an Asian man.
I would assess standing the way I assess other legal issues, which is to listen to the arguments made by the parties, consider the relevant precedents, and the constitutional principles involved, and make a determination.
Okay, let's go back to your favorite topic of this hearing, which is the criminal law cases you had as a district judge, and in particular the cases involving child pornography. Now, your defenders, both on the Democratic side of the dais and also in the press, have suggested that the criticism that has been raised has been somehow cherry-picked, that it's only some specific examples. So I'm going to give you an opportunity to discuss each and every case you've had, because looking at your cases, and I've now examined all of the child porn cases you've had as a federal district judge, there is a very consistent pattern. So let's start, and by the way, I'm excluding the cases. So Senator Durbin and Senator Coons focused on the Nickerson case, the Fife case, the Nguyen case, and the Hilly case. I'm excluding those because those are not child porn cases. Those are actual sexual assault of a child, which is markedly different. And I will concede when you're dealing with sexual assault, you have been willing to impose stricter penalties. So let's focus on actual child pornography cases. And let's go through each of them, because if it's right that we're cherry picking, then you should be able to explain quite powerfully. Now, your justification is that you're following the statute, and as you know, 18 U.S.C. section 3553 lays out the factors that as a district judge you had to consider in sentencing. And let's start with the Hess case, United States versus Hess. Now, in that case, a man sent 6 pictures of a prepubescent girl that he claimed was his daughter to an undercover law enforcement officer. Officers found over 600 images of child pornography, including images of sexual acts being performed on prepubescent children. The defendant pled guilty, and I believe in all of these cases the defendant pled guilty. So there's no question about guilt. They came in and pled guilty in your courtroom. The charge carried a mandatory minimum sentence of 5 years and a mandatory maximum sentence of 20 years. The sentencing guidelines recommended 151 to 188 months sentence. The government, as part of a plea deal, agreed to argue for 60 months, but didn't agree that that would be the sentence, simply that they would advocate it. And you, in turn, sentenced Hess to 60 months. So, under the terms of the statute, why did you choose to sentence Hess to the absolute lowest possible sentence you were allowed to sentence under law?
Thank you, Senator. I have spoken at length throughout this hearing about these cases. I've said what I'm going to say, which is I've taken every case seriously. These are very horrible
I'm asking you specifically about the Hess case.
I've taken every case seriously.
So you're not going to answer that?
These are very horrible crimes, as was that one. And as a mother, having to look at these pictures, having to follow Congress's directive, having to listen to recommendations like the government in that case, which argued for 60 months, I imposed the sentence that I believed was the sentence that was required by law. So
I believe you, and I've read your sentencing hearing in each one of these cases for which we have transcripts, and there are several of which we don't have transcripts. So in each of these cases, you read from the same script. So in each of these cases, you say that the distribution of child pornography is an extremely serious federal crime. And you point out that the crime involves people who are taking pictures and videos of real children while the children are being sexually abused. In Hess, you pointed out that he had hundreds of images of children in sexually compromised position. Some of them engaged in sadomasochistic acts. All of this I'm reading from you on the bench. And most importantly, the children in these pictures are not knowing and willing participants in the degrading conduct that was being depicted. They were being forced by someone off screen to commit unspeakable acts of sexual violence for the pleasure of the people filming them and for the gratification of people everywhere. And what concerns me is that many of those people have absolutely no shred of empathy for what that conduct does for the children who were being abused in this way. And you read this script in every one of these cases. So you talk about that these are terrible, terrible crimes. But you also, and in Hess, you said, I have to say that what I found particularly disturbing about your offense was that, quote, you apparently concocted a story about having photographed your own daughter, who you purportedly were willing to take pictures of to trade with other people. I know from your comments and from those who know you that you are unlikely to ever harm a child, which I find remarkable that you've got a child predator in your court who says, I'm unlikely to harm a child. And you say, well, you told me that, so clearly you're unlikely. But you say, but in the context of the crime, you represented that you would. That in and of itself is astonishing. So you talk about it as astonishing. You nonetheless sentenced him to the very lowest possible sentence allowed under law. And what's striking is in these cases, in half of them in 5, you sentenced the defendant to the absolute lowest sentence under law. Let's look at another case. Let's look at United States versus Chazen. Now, Chazen is a particularly nasty case. In Chazen, the defendant was accused, accessed a Dropbox that contained 35 videos and 13 partially downloaded files of prepubescent minor females engaging in sexually explicit conduct. At least 3 of the instances of prepubescent female children were engaged in sexual activity with adult men. The images included the sexual abuse of children, including those as young as toddlers. And several of these cases that you had involved the sexual abuse of toddlers, which is truly horrifying. In this instance, Chazen pleaded guilty. The guidelines recommended a sentence of 78 to 97 months. The prosecution argued that should be what the sentence was. And you sentenced Chazen to just 28 months. Why did you sentence someone who had child pornography of toddlers being sexually abused to 28 months, 64% below what the prosecutors asked for?
Thank you, Senator. You've picked out, 7, 8 cases. I've sentenced more than 100 people.
But not to child pornography.
And in every
These are your
case,
child porn cases.
in every case, Senator, I look at the evidence. I look at the recommendations of not just the government, because my duty as a judge is to consider all of the arguments that are made in a case. I look at the evidence. I talk to the defendants about the harms that they have engaged in. Many of these defendants are people who...
Okay, Judge, with respect, you're not answering my question. You're right. You talked to them about the harms. Let me read you again from what you said at the bench. You said in this instance, with Mr. Chazen, you said, among the defendants nationwide who received a below-guideline sentence on the basis of a downward variance as opposed to a departure, the average sentences ranged from 84 to 92 months. So that's what you lay out as the average. Our Democratic colleagues say, well, other federal judges sentence below the guidelines. That is true. A number of federal judges do. Our Democratic colleagues have not pointed to a single federal judge in the country who 100% of the time sentences child porn defendants to markedly below what the prosecution has recommended, unless you have a mandatory minimum and no ability to do so. In this case, you say comparable defendants are sentenced to 84 to 92 months. The sentencing guidelines by statute require you to have similarly situated defendants sentenced to similar sentences, but you don't sentence Chazen to 84 to 92 months. You sentenced him to 28 months. Why?
Senator, I've said what I'm going to say about these cases. No one case can stand in for a judge's entire record.
Okay, but I'm discussing every one of the cases. So if you're not going to explain it...
Senator, would you please let her respond?
No, not if she's not going to answer my question.
If you're just going to give a speech, then
you are not taking my time. If you want to filibuster, you're welcome to do so, but do it on your own time.
I would at least give you an opportunity to speak, and you should give her an opportunity to respond.
If she wants to answer the question, I asked her why
Please allow her to answer the question.
I asked her why she sentenced Chazen to 28 months when comparable defendants, in her own words, were sentenced to substantially higher, and she said she's not going to answer. Did you? I would welcome your answer, please.
Senator, I didn't say I'm not going to answer.
Okay, well,
I
then
said
please
my
tell us,
answer.
in this case, Chazen, why did you sentence him to just 28 months?
Senator, you're looking at the record. I don't have the record here. What I will say is that in every case, I looked at the recommendations of not only the government, but also the probation office, the defendant, the record, the evidence. I took into account the seriousness of the offense. And
by the way, one of the striking things in Chazen, the prosecutor comes in front of you and says, this is the prosecutor's argument at this point, and the prosecutor says, I understand from my experience before Your Honor, Your Honor's policy objections to the 2G2.2 sentencing guidelines. And he goes on to say, however, in this case in particular, the 4-point specific offense characteristic is justified because it contains sadomasochistic images of infants and toddlers. I'm trying to understand how you see someone that possesses images of infants and toddlers being sexually violated, and you sentence them to 64% below what the prosecutor is asking for. You don't provide a justification other than a generic concern that the guidelines are too high. You don't provide a justification as required by statute. So I'm asking you to take the opportunity to explain to this committee and the American people why in 100% of the cases, you have people with vile crimes, and you have language saying they're vile crimes. But then you sentence them to very, very low sentences. And why do you consistently 100% of the time choose to do that?
Senator, no one case can stand in for a judge's entire sentencing record. I've sentenced more than 100 people. You have 8 or 9 cases in that chart.
Okay, Judge, you said that before. These are the 8 or 9 child porn cases. I will say, to correct the record,
I just say to the judge, there's no point in responding. He's going to interrupt you.
Thank you.
Look, I appreciate the chairman trying to filibuster, and if you don't like your witness's answers, you're welcome to provide your own. She is declining to answer the question, and Chairman Durbin, if you want to join her on the bench, you can. But Chairman Durbin,
my job is to make
Chairman Durbin, I'm not interrupting your questioning.
I'm asking you to give her a chance to answer.
But she's consistently said she's not going to answer. I want to clarify for the record, by the way, the case I was discussing was Cooper and not Chazen. But Chazen is... the case that I was reading from your transcript was Cooper, but Chazen, all right, let's get to Chazen. I pulled the wrong tab. Chazen is equally horrifying, and you say in Chazen, this is something Senator Graham asked you. So the guidelines lay out different enhancements, and you say repeatedly, and this is true in all your cases, you say you disagree with the guidelines, you think they're wrong. And the 2 guidelines you disagree with is, one, there's an enhancement for use of a computer, and you say the world has changed, and now all of these are on a computer. And I understand that. I don't agree with you, but I understand that. That is a understandable thing to say. But the second thing you say over and over again is there's an enhancement for the number of images. And you say repeatedly, for example, in Chazen, you say, whatever the state of the law and technology at the time of the guidelines were first adapted, neither the use of the computer nor the number of images are especially aggravating factors today. Now, I find that bizarre. And you say it in every case. You say the number of images, it's not an aggravating factor, it doesn't matter, and you won't apply the enhancement. Do you really believe that a predator that has hundreds or thousands of images of hundreds or thousands of children being sexually violated has not committed an offense that is more serious than someone that has a single picture of a single child? A single picture of a single child is horrifying. But hundreds of children that have been violated, do you really believe that is not a more serious offense?
Senator, I did not have any cases involving hundreds of thousands of pictures.
No, I said hundreds or thousands. You had cases involving hundreds and you had cases involving thousands. You're right, you didn't have hundreds of thousands.
And I also applied an enhancement, just not to the degree of the guidelines.
You're right. It's a 5-point enhancement under the guidelines. You provide 2.
Yes, so not 0,
okay,
not
right,
the suggestion that I did.
But are you suggesting the number of images doesn't matter? Because you say it in court over and over again that the number of images doesn't reflect that it's a more serious crime. Do you really believe that?
Senator, as I said to Senator Graham, the court is taking into account a number of circumstances. The commission has done a report about the operation of the guidelines, which enhancements actually reflect different levels of culpability with respect.
So let me ask you this, Judge. You've said the purpose of sentencing is to distinguish between crimes that are not as serious from truly egregious crimes. Is that right?
No, Senator.
So what is the purpose of sentencing if it's not to distinguish from less serious crimes from truly egregious crimes?
It is to assign proportional punishment. It is to do justice in cases where you have defendants who are convicted of the same conduct but have differing levels of culpability.
Well, I will point out that you have a pattern. It doesn't matter how egregious the case is. Senator Hawley talked about the Hawkins case where you had an 18-year-old with pictures of boys as young as 8 being sexually assaulted and raped, and you sentenced him to just 3 months in jail. And I will point out the Stewart case, the last one on this list because we're running out of time. The Stewart case, you described that he had over 6,700 images and videos. So that's a lot, 6,700. That's a lot of kids being sexually assaulted. You have taken over a minute of my time, Mr. Chairman. So
you've been given extra time. You usually ask for it. You're given it.
Okay, I know you want to interrupt. I know you don't like this line of questioning.
I just want you to play by the rules.
I know you like to interrupt, but you've consumed a substantial time of my questioning, and I'm going to ask my questions, and you can, if Senator, you want to testify, you're welcome to.
Senator,
Judge,
you play by the same rules as every other senator.
In the Stewart case, you said from the bench, thus, although this is not necessarily an atypical case, your child pornography possession crime was egregious in the court's view. Okay, so this is a bad one. If you're actually sentencing defendants, you said this was egregious. What did you sentence Stewart for? The guidelines said 97, 121 months. Prosecutor said 97 months. You said it's egregious. 6,700 images. You come in with 57
months. Time has expired.
Why
Senators
did you
use 2 minutes over the allotted
57 months in the Stewart case? Do you want to address that? Because you're claiming it's cherry picking. In fact, you're welcome to explain any of these cases, but let's take the Stewart case. Why did you sentence him for half the amount?
You're not recognized, Senator. Senator Coons.
You don't want her to answer that question?
You wouldn't allow her any.
Mr. Chairman, she may answer the question. I've asked her why she sentenced Stewart.
You've gone over the time, Senator, by 2 minutes.
Why because you've interrupted me for 2 minutes, Mr. Chairman. Will you allow her to answer the question, or do you not want the American people to hear why, with someone she described as an egregious...
There comes a point, Senator, where you get a little bit...
Chairman Durbin, will you allow her to answer the question?
You won't allow her to answer.
I will happily allow her to... The question is,
Senator,
why you sentenced Stewart, an egregious child pornography possessor, to half of the amount requested by the prosecutor.
Please, Senator.
Will you allow her to answer the question, Chairman Durbin?
Senator Coons.
Why are you not allowing her to answer the question? There's not another senator here that you've not allowed her to answer the question. I'm not asking another question, but allow her to answer the question, Chairman Durbin.
Thank you, Chairman Durbin.
Why do you not want the American people to know what happened in the Stewart case, or any of these cases? Chairman Durbin, I've never seen the chairman refuse to allow a witness to answer a question. You can bang it as loud as you want.
Well, I can just tell you, at some point you have to follow the rules.
Okay, will you let her answer the question? You've been interrupting, and by the way, with Senator Graham, it went 10 minutes over. You've taken a big chunk of the time. Will you allow her to answer the question?
You've given her...
Why are you afraid of her? She's welcome to answer it right now. Will you let her?
Senator Coons.
Will you let... So no, you don't want her to answer the question?
Senator Coons.
Will you let her answer the question?
Chairman Durbin.
Apparently, we're very afraid of the American people hearing the answer to that question.
We here in the Senate, in this committee today, are in the middle of a policy fight. It's my understanding that across this nation, more than 70% of district court judges who impose sentences in cases such as the ones that have been so vigorously debated here depart downwards from the sentencing guidelines, from the requests of the prosecutors. And as you've explained repeatedly and in detail, that's because a sentencing judge is required to weigh a whole series of factors. How many opinions have you written as a judge, Your Honor?
I've written at least 570 opinions, Senator.
And in how many cases have you imposed sentences as a federal judge?
More than 100 cases.
And across all of those, we've just heard very forcefully assertions made about you and your character and your capabilities, your background, narrowing in on just a few. And I would simply put, for those who are watching and trying to understand what all of this is about, that in an attempt to distract from your broad support, your deep record, your outstanding intellectual and legal credentials, that we are taking what is a policy dispute that should be decided by members of the Senate. If we want to change the sentencing guidelines to make them mandatory rather than advisory, if we want to change the structure within which a federal judge imposes sentences, we could do that. But to demand that you be held accountable for this practice that is nationwide and is years old, I view as an unfair misrepresentation of your record. So if I could, let's go to something that you did as the vice chair of the Sentencing Commission, an important vote that you took in 2014. Because in my view, it shows how fundamentally misguided are the attacks that try to characterize you as someone who, at all costs, will do what you can to help criminal defendants. Let me just lay out the context for a moment. In 2010, Congress, enacting a policy choice, unanimously passed the Fair Sentencing Act, a bill that reduced the disparity in sentences between crack cocaine and powdered cocaine from 101 to 18 to 1. And the Sentencing Commission unanimously concluded this law meant those currently in prison on crack offenses could seek to shorten their sentences. 4 years later, the commission further concluded that individuals who provided substantial assistance to the government, people who cooperated, who helped out the prosecution, could use this law to shorten their sentence retroactively beyond any break they might have gotten for their cooperation. But you disagreed. In your public remarks at the time, you explained that although, given your prior service as a federal public defender, it might seem logical you'd support this direction, you could not do so because you concluded it was manifestly inconsistent with the law and would create unfair disparities between those previously sentenced cooperators and those sentenced today. Essentially, if I understand your view, it was that the sentence of a cooperator shouldn't be understood to be based on the sentencing ranges modified by the Fair Sentencing Act, but was best understood as a fixed discount of the mandatory minimum that a Fair Sentencing Act had not changed. I know this is technical, but I just wanted to make sure I'm characterizing this correctly before reaching a conclusion. Do I understand the context correctly in which you made this decision?
Yes, Senator, perfectly. It was debate among the commission, one of the very few in which we couldn't reach agreement about the retroactive application of the Fair Sentencing Act reduction.
And so, just to finish the framing, the Sentencing Commission, which often decides things unanimously, was sharply divided. And here's who was on each side. You voted to deny relief to cooperators, to deny them a pathway towards reducing their prison sentences. And you were joined by two conservatives well known to us, Judge William Pryor and now Judge Dabney Friedrich. And the three of you were outvoted by four commissioners, which included Judge Hinojosa, an individual nominated by President Reagan and described as a hard-nosed, no-nonsense judicial conservative, who was on the other side of the argument from you. So you've got four commissioners, including an outstanding conservative Reagan nominee, and they thought the law could be interpreted to give a break on sentencing. And you were on the other side of that argument. If, as someone has tried to paint you, you simply were determined to give every break you could to criminal defendants, all you had to do was join the majority, and this would have passed. But that's not what you did. Help me understand why not.
Thank you, Senator. As you say, this is a sort of technical, kind of in the weeds discussion, but the top line is that when I looked at the issues and I looked at the law, it was my opinion that the law did not provide for the further reduction that was being considered.
So across an incredibly broad range of sentences you've had to impose and cases on which you've had to opine, I'm picking this one in part because it's not getting any attention in this confirmation process. But for folks who'd like some insight into how you make decisions and how you explain those decisions, there's a video, it's publicly available, of your April 2014 of the public meeting of the Sentencing Commission where you laid out your position. So I encourage folks to just watch that. And they'll see a jurist who understands that her commitment above all is to determine what the law requires and then follow it. In my view, that's an individual who belongs on the Supreme Court. By the way, your position that the law required that there not be further breaks given in this context ultimately won the day. My colleague from New Jersey made a point of mentioning a relevant case, United States versus Booker, yesterday. I have to say that in this case, it was decided in Coons versus United States with a K, not a C. Look, we all have our judicial record from which we work. But the Supreme Court ruled for exactly the same reasons you did in this argument that was made public. So I just think, Your Honor, this is an example of you looking hard at the law, making a tough decision, ultimately being vindicated in that decision, but taking a position that is not the caricature that's been proffered by some of you. Yesterday, I ran through a number of the letters and statements that debunk some of the attacks that have been levied based on a handful of sentencing decisions. There was the National Review piece by a conservative former prosecutor who calls out the smear on your sentencing practices in cases involving child pornography. The statement by the Fraternal Order of Police and the International Association of Chiefs of Police endorsing your even-handed and judicious approach to the law. The glowing letter from 24 prominent conservative attorneys and the resounding recommendation we heard in person from Judge Griffith. There's also been received here a letter from a number of retired federal judges, including 2 Republican nominees, rejecting this mischaracterization of your sentencing record. As I've said, this is a policy dispute that we should be deciding, not an appropriate basis on which to mischaracterize your record or your character. We have letters from the National Coalition of Domestic Violence, in addition to these law enforcement leaders, from survivors, advocates, crime victims. The breadth of your support from the very communities my colleagues have suggested you're making less safe shows just how off base these attacks are, and in my view is a testament to your qualities and qualifications. So we all agree, all of us, that it's critical to protect our children and prevent the kinds of heinous crimes we've heard about in some detail earlier today. It's why I'm introducing a bipartisan reauthorization of the Victims of Child Abuse Act, something that we could act on as a committee to do our job, which is set policy and pass laws. But I also frankly think we need to be mindful that we are asking of you to get engaged in that policy dispute in front of this committee, which is not the role of a judge, something you well understand. Let me turn, if I could, to another reason I think you're deeply qualified and that you will bring something important to the Supreme Court. Brian Stevenson, one of America's leading civil rights lawyers and by happy coincidence a Delaware native, has spoken about how achieving justice requires being proximate to the people most impacted by the criminal justice system, and you've done that. As a public defender, you've represented individuals in the criminal justice system. As a district court judge, you have looked individuals in the eye and told them that for their crimes against society, they will spend years or decades in prison. You have met with, fought for, and advocated for victims. You've also studied the big picture. As an effective and engaged member of the Sentencing Commission, you've pored over data, reviewed thousands of letters, and thought hard about the appropriate national approach to just punishment in a more policy-oriented role. You've also thought about the big picture as a judge when considering the precedent that your opinions set. I'd be interested briefly in how your experience on the Sentencing Commission shaped your approach as a district court judge and how the interplay of all these factors might shape or contribute to your decisions as a Supreme Court justice.
Thank you, Senator. One of the things district judges, sentencing judges often say when asked about the task is that sentencing is the hardest thing that a judge has to do. And it's in part for the reasons that you have articulated. That it's one thing to understand the law, to read it in a book. It's one thing to look at data and numbers and make policy based on that. It's quite another to have someone in the courtroom, whether as a victim of crime or a defendant who's perpetrated a crime, and have to decide how to proceed and pronounce a sentence on that individual. The work that I did on the Sentencing Commission, which was prior to my becoming a district judge, I think enabled me to understand unwarranted sentencing disparities, to understand some of the policy reasons behind the guidelines, and to make the kinds of evaluations that the law now requires since the guidelines are no longer mandatory. And I felt better in a sense about the task of calculating the guidelines, which is what courts have to do at the beginning of a sentence. They can be a little complex, and having been on the Sentencing Commission, I think that helped. And some of these cases do make their way to the Supreme Court. So I think that I am prepared to handle the cases that involve sentencing that do go to the court.
In preparing for this confirmation, I went back and read a lecture you gave, but it was later published in the Harvard Law Review, about the balance, the challenge of sentencing, about that moment. I had the joy, the blessing of clerking for a judge on the Third Circuit. My legal skills and talents did not allow me the opportunity to clerk for the Supreme Court as you did, and also the District Court and also the Circuit Court. But I clerked for a judge who I first met when she was a District Court judge and imposing a sentence on someone who was a crack dealer. And she did a remarkable job of speaking to the victims, speaking to the community, speaking to the prosecutor and the defense attorney, and then speaking directly to the defendant in imposing a very long sentence. And as I got to know her later, I recognized that, as a member of our community and as someone who saw the importance of that moment, that public moment of helping the defendant understand what they'd done so that they might somehow change, but also helping the victims understand what had happened, that she took that very seriously, incredibly seriously. In the Harvard Law Review publication of your remarks, you said that you're persuaded by the theories of punishment that accept all human beings are responsible moral agents, and you view punishment as a necessary consequence of the defendant's decision to engage in criminal behavior. You also went on to say that the challenge is balancing the acknowledgement all of us are more than just the worst thing we've ever done, but there is a need to ensure the defendant is adequately addressed and punished. What I think you say in that lecture, what you've shown across the arc of your public service, reveals someone who understands the appropriate need for punishment in our society, but who is also striving to follow the balance of recommendations, guidelines, statute, and the context and facts. And I trust that as members of this committee and the Senate as a whole and the general public take the time, which they should do, to give a fair reading to the whole scope and arc and reach of your service, that they'll see you as someone who cares deeply about our Constitution and the rights that make us free, as you said in your opening statement. Your career in the law, your service on the bench, your thoughtful responses to questions put to you, the way you've maintained your composure, all impress me. As I mentioned, I don't think labels such as a judicial philosophy are always that meaningful or dispositive. I think in your case, a deep admiration for the Constitution and an understanding that the role of a judge is a limited one are critical and qualifying. You opened yesterday by referencing how your parents were educated in racially segregated schools in Florida, but how you, just one generation later, were raised in integrated schools and had far greater opportunities to put your evident, God-given talents to work in service to our nation. You cited this one generation change as an example of the greatness of America. Of course, the Supreme Court played a central role in more correctly interpreting the Constitution and applying it in a manner that allowed this reversal of unjust law to occur. I think the experiences of your own family and your connection to the experiences of trailblazers who came before you, on whose shoulders you stand, has meaningfully shaped what kind of a justice you will be. I think you know in your bones how important our Constitution and the rule of law is. And I think, as someone who served on the Sentencing Commission, a public defender on the trial court, and appellate court judge, you have the ability to see across the whole scope and reach of how the law impacts families, communities, and our nation. Last, in some ways, I think, most importantly, I've learned that as a person and a judge, you have humility. Judge Griffith, who came before this committee to introduce you, and scores of others we've heard from, I've just referenced, have lauded your practice of judicial restraint. And you've said a core component of your philosophy is your understanding that the judge's role is a limited one. Well, I think restraint is a core part of your approach to decision-making, partly because you are a judge who is humble enough to know that the Constitution and the laws passed by Congress say what the law is. The judge has a limited role in deciding questions of law based on facts presented. Penn Law Professor Lisa Fairfax, your other introducer, your dear friend, explained that since college at Harvard and then through law school, you've been a mentor and a role model. She praised your warmth and intelligence, your devotion to friends and family, but she also mentioned your humility. She knew you were honored and humbled by the significance of this moment, not what it means for you, but what it means for our nation. I remember thinking about this on Monday, and I had a chance to talk to your brother Ketanji, and he mentioned that he knew you were destined for this moment your whole life. I am sure he would say you've been exceptional since you were student body president at Palmetto High School. Suspect your wonderful family upbringing is partly responsible for this facet of your character. I suspect your faith has played a role in sustaining you, as mine does, and so does many others in this room. I've often found instruction and comfort in the verse, "What does the Lord require of you but to do justice, love mercy, and walk humbly with your God?" I'm not going to ask you to reflect on that verse, Your Honor, but I wouldn't be surprised if it's one of your favorites that sustains you. Let me close by returning to what Judge Griffith said when he told us in his heartfelt introduction of you on Monday, and something you've also shown in the hours you've been grilled by this body. He'd already written a letter to this committee delivering his endorsement. He took the extra step to then amplify it in person. And he did so because of confidence in you and because he was delivering a message to us as a committee that Supreme Court confirmations should be more than just exercises in partisan tribalism. He said there should be nothing unusual about a judge who just happened to be appointed by a Republican president and who holds conservative legal views coming forward to support a nominee with your impeccable qualifications and character, especially a nominee whose legal opinions, whose actions and decisions as a judge, he was in a position to review for years, given that you were a district court judge and he was a circuit court judge. Look, our confirmation hearings for justices have sadly been devolving over many years into longer and longer exercises of partisan politics, punctuated by just brief glimpses and occasional thoughtful examinations of a nominee's judicial decision-making and views on the Constitution, which should properly be our main focus. I have to believe this sad state of affairs troubles my colleagues of both sides and all who watch this. But as I reflect on these hearings, I'm hopeful that your gracious, thoughtful exchanges with some members will be remembered as just one more service you've rendered to our nation. And I hope some watching these hearings will be reminded that even though we disagree with the policy preferences or opinions of a nominee, we should all recognize when a nominee is fundamentally qualified, deeply committed to the Constitution, rule of law, and a person of great character. Judge Griffith reminded us at the outset of this week, and I quote, "As Justice Scalia taught us for so long, an indispensable feature of the republic the Constitution created is an independent judiciary of judges who've taken an oath not to a president or party, but to the American people and to God that they will be impartial." I couldn't agree more with Judge Griffith. You've demonstrated your unwavering commitment to that oath and your impartiality, your abundant qualifications. It'll be my honor to support your confirmation for Associate Justice. With that, Mr. Chair, I yield.
Thank you, Senator Coons. The Senator from Nebraska, Senator Sass.
Thanks, Chairman Durbin. Judge, welcome back. I'd like to associate myself with parts of what Chris said there in his closing. I would differ with him about whether or not getting to precision on judicial philosophy matters, but you know that. You and I have been wrestling about it for a couple of weeks. But I'd like to affirm Chris's point about the beauty of the hymn to America you told, and through the eyes of your parents and the changes, the growth in the country over the course of the last two generations. And the Wall Street Journal had an editorial this morning that said pretty much the same thing as Chris just said, which is that the hymn to America that you gave in your opening on Monday afternoon and some of your comments yesterday were inspiring and beautiful. So I associate myself with Senator Coons on that. I'd like to talk a little bit about your time as a judge and particularly how you see development and growth and change over that time. So take us back 9 years and then maybe 5 years ago and then today. How has your approach to being a judge changed from year one to year 5 to today?
Thank you, Senator. I do think there was a little bit of growth. I hope there was a little bit of growth. Certainly in year 1 and year 5, I was still a district judge, and both of those years differed dramatically from my work as an appellate judge, which is where I'm currently stationed. In every job, in year 1, you're new, you're trying to figure things out. I don't know that I had quite pinned down at the very beginning exactly how I would approach cases, but by the time I got to year 5, I think I had a really good sense of this judging thing, and was able to demonstrate in my opinions, the many, many opinions that I've written, the way in which I go about making my decisions. I was able to demonstrate clearly, I think, that the particular parties in the case, the issues in the case, what it's about, from a standpoint of personal preference is not an issue. I'm setting those things aside. I am ruling from a position of neutrality and trying to determine in every case what the law requires. I am looking at only the facts and the law in the case. I'm evaluating the arguments of the parties, and if it's statutory interpretation, I'm trying to ascertain what Congress has intended. I am committed, I think my record shows, to the understanding that that is the role and the only appropriate role for a judge.
I'd like to talk a little bit about the troubling pattern we see on law school campuses and across higher education more broadly, especially in the last 5 years. There's obviously a trend toward shouting down and canceling opinions that are outside the left-leaning mainstream. Calls for firing professors, canceling professors, shouting down and sometimes threatening speakers who bring diverse opinions, calls to discipline fellow students. These tactics are increasingly commonplace, particularly against conservative speakers and professors and students, but also increasingly against traditional liberals. I'm a former college president, and one of the sort of oddities that doesn't fit inside the tribalism of how a lot of times media covers things in DC. One of the oddities for me is how often I have liberal professors reaching out to me saying that their experience on campus is becoming much less interesting, that the divide on American political campuses is less and less conservative policy leaning versus liberal or progressive policy leaning, but more and more liberal versus illiberal. And I think these campaigns are obviously deeply problematic. They shut down debate rather than teaching students how to engage ideas that they might not have encountered before, which is also a pretty decent definition of education. If you already knew everything before you ever encountered a new idea, you wouldn't need to write checks or take time off of productive life. So there's obviously a tendency in response for students to self-censor rather than learn from each other, and this robs students of the chance to engage with ideas from across the political spectrum. But in particular, in law schools, it robs students of the opportunity to learn how to consider an alternate position and argue a different point of view than they might have had. So given that you're a debate champion in earlier days as well, I'd like to ask if you agree that law students should be engaging with ideas from across the political spectrum, even those they disagree with, rather than trying to shun those different ideas.
Thank you, Senator. Let me just say, in part because these issues are things that could implicate matters that come before the courts, I will just say that as a general matter, law school, like many schools, is a place where ideas and perspectives are considered. And in the law, as I've said, it's important for the judge who's making the decision to have different arguments. And so one of the things that traditionally happens in law schools is that you are trained in law to make arguments that are at times not even the arguments that you personally agree with, because the understanding is that in litigation, in disputes that come before the court is going to want to hear from different viewpoints. So in that sense, the essence of legal instruction is to have different arguments being made, because that models in great part what happens in a courtroom.
I really am not trying to ask any kind of gotcha question here. I suspect we highly agree, so I don't understand the qualification you put at the beginning. There's no sort of second order fork on my question. It is better to debate ideas that you disagree with than shout them down, isn't it?
It is better in law schools to make sure that there are ideas from all perspectives, and in order to have that happen, they can't be suppressed.
So you don't want students shouting down other students or visiting professors, right? I mean, I'm honestly, I didn't think there was any chance we would differ on this, so I'm not.
Yes, no, I'm not.
Okay.
I'm not suggesting
You're
that we do
against
differ.
canceling people, I assume.
I'm not suggesting that we differ. What I'm saying is that these issues about speech on campus and the like are the kinds of things that are issues that are working their way, in different formats and different ways through the courts, and so I'm just being careful in terms of my answers.
Okay, I'm trying to lead you because I want to, because I think American civic health will be better off. You're going to be a hero. You are already a hero to lots and lots of kids, students, maybe some bound for the law, but more broadly, students across the country. And I think it's in America's public interest for them to hear you as an advocate for the full, vigorous, strong kid debate of different views. And so I suspect you are an advocate for vigorous and robust debate. I don't see how you might be constrained against saying that because of future cases, but I'm going to just assume we're mostly aligned on this.
I think that's a fair assumption.
Thank you. I do want to make, before I move on, just because we've had a number of members of this committee comment on cameras in the court. I've made my position on this clear a lot of times, but if I can give a tiny bit of friend of the court brief in advance, because I think when you're on the court and you all continue to debate this issue, I think it should be a decision for the Supreme Court to make about whether or not there are cameras in the courtroom, not a decision for the Article 1 branch to make for Article 3. But I think it's incredibly important for us to recognize, because I think I differ from a lot of my colleagues on this who are advocates for cameras in the courtroom. I get their position that transparency is a virtue. Transparency is a good thing. I also believe that pen and pad can facilitate a whole heck of a lot of transparency just fine. And it's healthy for Americans to recognize the second and third and fourth order effects of cameras. A huge part of why this institution doesn't work well is because we have cameras everywhere. Cameras change human behavior. We know this. You don't have the same kinds of conversation over the dinner table with your family when you're wrestling through issues and apologizing for something and saying, I said this before, but maybe I should modify what I said. My tone was jerky. My substance didn't account for your position. There's a whole bunch of things that humans can do if they're not immediately mindful of some distant camera audience that they might be trying to create a soundbite for. And Instagram can be useful for some small things, but for intellectual discourse, it is not a friend. And I think we should recognize that the jackassery we often see around here is partly because of people mugging for short-term camera opportunities. And it is definitely a second and third and fourth order effect that the court should think through before it has advocates in there who are not only trying to persuade you 9 justices, but also trying to get on cable that night or create a viral video. So for what it's worth, I hope that the court doesn't respond to some well-meaning impulses from the Congress to push for cameras in the courtroom, but also some bullying. And there are ways that you can get to a lot of transparency. Audio recordings are increasingly released from the Supreme Court in timelier fashion over the past few decades. So for what it's worth, I'm glad that you on the court are making that decision, and I hope it isn't made for you by the Congress. I want to go back to the legitimacy of the Supreme Court. That term has been used a few times over the last 3 days. Do you think the Supreme Court is legitimate?
I do, Senator.
And so some of the ways that the court has been derided and called illegitimate by members of the Senate include, over the course of recent days and weeks, quote, leans into extreme partisanship, leads into extremism, twists the law, threatens basic liberties, has been hijacked by Republicans. These kinds of attacks undermine the public's trust in the court. we need the public to believe in the legitimacy of its government, including all three branches. So I would ask you, do you agree with these characterizations of the court that have been levied in this room over the last few days?
Senator, I have nothing but respect for my former judicial colleagues, my current judicial colleagues, and hopefully my future judicial colleagues. I do believe that we need legitimacy. I've said that that's the currency of the court, and I look forward, if I'm confirmed, to joining the institution.
So do you think there could be any opinion that would be handed down this term that could undermine the legitimacy of the court?
Senator, I think the Supreme Court makes its determinations, and all of them are precedents, and they are entitled to respect.
I'd like to come back to our conversation from yesterday. You pointed out a number of times that as both a district and now a circuit court judge, you were constrained and bound by the Supreme Court's holdings. You mentioned a couple of times that you haven't had a chance to do much constitutional interpretation for yourself. I largely agree with the way you framed most of that for the lower courts, but I think you would also agree with me that the job of a Supreme Court justice is different than a district court judge, and in certain ways from a circuit judge as well. When you serve on the Supreme Court, you'll have to interpret what the Constitution means, and based on what you told us about the constrained role on the lower courts, lower court decisions would then not be able to answer how you would approach the new job you would have on that highest court. And so that's why I thought our conversation on judicial philosophy yesterday was somewhat helpful. I'm not a lawyer, but I think you took a lot of us to law school yesterday in ways that were helpful. And in particular, you walked us through some different schools of constitutional and statutory interpretation in ways that I think were good for the committee, were good for the court, and were good for the public more broadly. So I guess I would ask you, if you could take us to law school one more time and walk us through some of the different approaches to substantive due process and unenumerated rights. What are the different ideas on the Supreme Court and in the broader legal community?
Thank you, Senator. I am not mostly familiar with the Supreme Court's precedents in this area. It's been a while now that the Supreme Court has determined that the 14th Amendment, which guarantees due process, includes a substantive component in addition to procedure. The term due process, one would think, is just about the procedures that the government has to afford you before it affects your life, liberty, or property. But the Supreme Court has also said that that protection extends to certain personal, individual rights that relate to dignity and autonomy, and that are deeply rooted in our nation's history and traditions, or implicit in the concept of ordered liberty. And the kinds of things the court has recognized pursuant to that line of jurisprudence are things like marriage, interracial marriage, the access to contraception, a woman's right to terminate her pregnancy, abortion, pursuant to or subject to the framework established in Roe and Casey, travel, the child rearing, the ability to direct your children. Those are some of the rights that have been recognized pursuant to the 14th Amendment due process clause. I'm less familiar with the sort of scholarly debate outside of the Supreme Court's rulings.
So will there be new ones in the future?
Senator, I am not able to forecast. In every case, the Supreme Court is looking at a particular set of circumstances consistent with the Article 3 requirement that the court look only at cases and controversies. So it would depend on what cases came before the court.
So I think that gets at the challenge here that you and I have been going back and forth on over the course of a couple of weeks, because I get the modesty points about being on the district court, but it seems pretty important to understand what the limits might be as a justice. And so I think this morning, again, you stated that I think the quote was that your judicial philosophy is your methodology. But I think that a judicial philosophy of some kind is necessarily an input into your judicial methodology and into every justice's actual jurisprudence on the court. And that's why I think it's important for us to unpack that, because the philosophies that you've outlined for the committee, again, I think yesterday's back and forth that you and I had on Breyer v. Scalia, is important, and you wouldn't claim any of those philosophies for yourself. And yet I think the philosophies ultimately instruct judges on the sources and the tools they consult, on how they discern intent, on whether the Constitution is protecting specific, limited, and defined principles or more general values, and whether modern values can be used to infuse our understanding of the Constitution. So again, when you narrated a bit of the debate between Justice Breyer, I know you've got lots of intellectual inputs in life, but you've credited him as a brilliant jurist and role model before. And the Scalia debates, you didn't really tell us who you thought got the better of the argument. And so I think throughout these 2 days, you've focused a lot on what the Supreme Court has said, and I think that is helpful and important. But I've been also trying to get at what you think the limits might be on what Justice Jackson would be constrained by. So I feel like I believe we still haven't heard your judicial philosophy, and